Previous President Trump went out, current President Joe Biden went in. We've got various Democrats on Capitol Hill who have some ideas about what to do with relation to tax laws. And so across the board, we've got a lot of interesting things that are happening, but a lot of things that we better be ready for. Wealth transfer. That's what it's all about. It's about wealth transfer. What we have today, and what we may have in the future, and what we may provide to our loved ones. How do we do that? I'm going to provide you some key terms in the wealth transfer. Exemption. We're going to be talking about exemption. Many of you, I'm sure, already know what the term exemption means, but it is the maximum amount that we can give without being taxed, also known as exclusion. Note, the giver, that's you, that's your estate, is taxed, not the beneficiary, when it comes to all these areas we're talking about. Estate tax rate, that's the tax percentage levied on the amount in excess of that exemption. And the step up in basis. How many of you have heard of step up in basis in discussions that you've had in the news, in President Biden's initial address to Congress, both houses? Step up in basis. It is the price that one paid to purchase an asset. At death, that basis increases or steps up to fair market value on the date of death. Therefore, the gain is made during the life is not taxed. All right, I mentioned to you before that I would like some volunteers. Just give me your name, and I'm going to make something up to give you an understanding as to what that means. Who wants to go ahead and quickly volunteer here? Go ahead, I'm sorry, it's Bob, right? I think it's Bob, yeah. All right, so say Bob purchased some stock about 20 years ago. Bob, give me a company you like.
A company you like.
Detroit Edison.
Bob purchased some stock in Detroit Edison in 1990, and he purchased it for $10,000. Here in 2021, it raised all the way to $50,000. Now, Bob, if you were to go ahead and sell that stock today, you're going to pay capital gains tax on that against $40,000. That's the recognized or unrecognized gain, $40,000. Now, Bob, years and years and years and years from now, say it's 2030, 2035, doesn't matter, you pass away. And at that time, it's worth $75,000. If we keep our step up in basis, it's not $10,000 that suddenly $75,000 is going to be deducted from, and now you got $65,000 that you have to pay taxes on. No, it steps up in basis. It now is equal or worth $75,000. Net amount to go ahead and tax against, zero. Well, let's see what Capitol Hill has to say about that. Also, before we get into there, let's talk about the wealth transfer methods. Those include a will. How many of you have a will? Please, by show of hands. Thank you. A will, of course, is your way to provide to your beneficiaries. It can identify what assets you have, either specifically or generally, and identify who receives what. It must go to probate court, and that can be a problem. Things become public, fights become more common, and it can drag things out. So what do people do often? They end up with a trust. How many of you have a trust? Great, quite a few of you. All right, again, it's designed to stay outside of probate court, and it's designed to limit your taxes. We got a question down here though. Will we still be able to do that with new tax law? We're going to discuss that. Of course, there's also gifting. Gifting on a yearly basis, and I know that some of you from there, if I can move this back just for a moment, are able to see some of the things that are way over there. I'm going to cut the mic just for a second if anybody's back there, just so I'm not going to go ahead and reverb this. I want to make sure everybody can see properly. Is it cut? Okay. Yep, sure sounds like it. Can you see back there the bottom words we have here?
Yes.
Everybody over this way? Okay. You can put the mic back on.
Yes.
Okay, great. Excellent. All right, so then, we're gonna go to the tax issues impacting wealth transfers. Number one is, what's the income tax rate? What are we getting charged year after year after year by our government? Second is gifting. We've got an annual exemption, and we've got lifetime exemptions. We'll talk about those in specifics. We've got estate tax exemptions. What's that amount gonna be? We have estate tax rates, the amount that's paid on the amount that we are above the estate tax exemption. We've got capital gains, the step up in basis we talked about a moment ago. And we have charitable gifts, and those charitable gifts are tax-free. Now, Donald Trump basically took something in 2016, and he had the tax reform of 2016 taking what was the system at the time and bringing it a step further. Let's take a look at what he did. He had the highest income tax rate of $37,000, and essentially today, if we were to have it, it's over $523,000. That's when we get charged $37,000, at 37%. Gifting, annually, that was a continuation. We've been kind of stepping up over the years and so forth. $15,000, but here's the critical point. We can give $15,000 to as many people as we wish to. Now, if I had all the money in the world, I'd give each one $15,000, and I'm not limited to that, okay? Lifetime, we've got $11.7 million without tax, and that's what we basically have with our estate, which is our trust, maybe our will, maybe other things that pass from us after we pass away. The estate tax. The exemption, again, it's a combined exemption between what we have for a lifetime and also what we have at $11.7 million for after we pass away. So example, I'm going to pick on Paul, I know he's here right now. Say Paul, during the course of his lifetime, gives away $2 million, okay? God forbid, he passes away while the estate tax exemption is still in this level at $11.7 million. He has $9.7 million that he can provide to his loved ones at the time that he passes away. Now, it's a high number. 99.5% or so are not going to be hit with that. I'm sorry, go ahead.
Does that include the less than 15,000 you give away annually? How do they track that?
Good question. And the question was, how does that $15,000 that we give away annually catch up with our $11.7 million? The nice thing is, it's an exemption. So at $15,000, in fact, Jerry just gave me $15,000 the other day, didn't you, Jerry? No. At $15,000, we can give away that 15 to Jerry, we can give it away to Paul, we can give it away to Bob, I can give it away to you, anyone. We can give as much as we want to, and as long as it's limited to $15,000 per person, no impact whatsoever on our $11.7 million. Okay? None. There you go. Making sure you point to each other, see who's getting the money, right? All right. So that's what that states for. And then we're at a tax rate above that exemption of 40%. So, yeah, you go $1 million above that, and you're going to get 40%, you're going to have $400,000 tax hit, essentially. Okay?
Question.
Yes. Yep, question. Mary.
A couple of years ago, a person bought a car for their son,
Mhm.
and it was well over $15,000. If I would have made that, if that person,
If that person, that's all I heard is if that person,
if that person would have just given $15,000 to that son, and he bought a car with it, would that count as a gift?
well, again, keeping it at 15,000, the exemption's there. Okay? So no counting. You make that $15,000 $1, well, now you got to go ahead and tell Washington, and they got a little ledger over there somewhere, wherever they have it, that says that you spent $15,001 in terms of a gift to somebody, or the $1, should we say? Okay, does that make sense? So whether it's a car, which can be assessed at whatever fair market value, or whether it's $15,000, yeah, that's exempt. Anything above that is what we call reportable, not taxable, but it's reportable, okay? You don't get taxed again under the current system until we get $11.7 million above that, okay? So again, I picked on Paul before about that $2 million that he gave away during the course of his lifetime, and he still had $9.7 million to give. That right there is all covered by the estate tax exemption, the estate and gift tax exemption. It's a unified credit, okay? I see a question up back there.
Yeah, how do they know you're giving $15,000 away? I mean.
They don't, not 15,000, but we are required to report as U.S. citizens.
It's our good judgment as to whether we report it or not. Well,
That's kind of an honor system. You've got it. Kind of an honor system. We as law-abiding, tax-paying U.S. citizens and so forth, you know, let Washington, D.C. know when and when we haven't gone beyond our. I'm sorry?
How many people do that?
How many people do that? That's an excellent question.
None.
Yeah. That's an interesting question. Yep. So, and then we got the capital gains at, and again, possibly none. Remember that step up in basis. The point that I used, Bob, is an example there for about that DTE stock that was $10,000 and it went up to $50,000 or even went up to $75,000 upon death. The step up, no tax. Okay? So there gets back to your question there. Nobody has to worry about whether they're being honest or dishonest because we all get the step up at death. Wait till we have some other issues coming up though on the proposals. Because the proposed tax law changes may rock your world. And we got all this to go ahead and rock. I will not do the pelvic thrust. I cannot do it anymore anyway. But we've got three things we'll talk about right here at the bottom. Gifting, at death, and then capital gains. And you'll see that each one of those could significantly decrease. President Joe Biden, his American Families Plan, we're just starting to get some sense of it. We got some sense of it on the trail, the campaign trail. We got some sense of it during the course of early on. Of course, he had addressed the joint houses of Congress and the Senate and the House of Representatives. And we got some initial understandings. What does it all mean? Let's summarize it a little bit. So the highest income tax rate, he's got it at 39.6 once somebody reaches $400,000. The gifting, annually $15,000, but he's uncertain about that. And like you mentioned a moment ago, who's going to count anyway? Lifetime, $1 million without tax. Now he's taken that unified $11.7 million and he's proposing to take $1 million of it that you can give away during lifetime without being taxed. And then he's got the other portion at an exemption of $3.5 million. Again, I have in the words in parentheses there, during the campaign. He did not address this during that address to the Joint House of Congress, but he basically has said all along he wants to see $3.5 million. We've got the tax rate above the exemption up to perhaps, now this is what he said in his campaign, 65%. We went from 40% currently where we are now to maybe 65%, but we haven't heard a word since he took the oath of office. So who knows right now? Capital gains at death. That step up in basis, he wants to get rid of it. Sorry, Bob. Now you're stuck with that stock that DTE that was at $75,000, and your estate is going to pay $65,000 against $65,000 of taxes. And let's see, what else we have here? We do have the $1 million to $2 million exemption. So you might take, to a certain extent, let's call it a $1.75,000. So $1,075,000 if you go above it. He is given an exemption, but it's a lower exemption. Let's go on to the next one. Now we got Senator Bernie Sanders. And he loves to call it for the 99.5% Act. And his point there is, hey, it's only the 0.5% that I'm worried about. That's all I'm worried about. And so here he is saying, gifting annually, we're going to limit it to $30,000. Yeah, you can give $15,000 to this person and $15,000 to that person, but stop. That's it. Not going anywhere further. He doesn't want anything further beyond that. A lifetime, just like President Biden, $1 million without tax, then we get taxed. Estate tax. Now he's the one who's speaking on Capitol Hill about this number, $3.5 million. Tax rate above the exemption, between 45% to 65%. There goes that 65% number again. We'll show you where it cuts in though. Maybe it's, not going to affect anybody in this room. Capital gains at death. Step up in basis is unclear about his feelings on that. Again, that point about the DTE stock we're talking about. But basically the bottom line is he supports some legislation. Well, whose legislation is that? This man here. Senator Chris Van Hollen, he's a Democrat from Maryland. He's been in Congress since 2017. So he's a young pup. He's a newbie, as Jerry likes to call him. And Chris Van Hollen is on the warpath. Or, on the other hand, he might be putting out a test balloon. We're not sure what's going on for sure. Let me show you what he's talking about, though. He wants a sensible taxation and equity promotion. He calls it his STEP Act. And it's a goal to end the step up in basis. No more, Bob, sorry. DTE, you're for sure stuck at that point. He will tax gifts. So let's think about any gifts we're giving. He'll tax transfers to non-grantor trusts. Now, non-grantor trusts you're going to hear about in a little bit. Those of you who said you had a trust probably have what's called a grantor trust. That's a trust, just like I have, my wife has, is you settled your own trust, you've got it for yourself, you can change it whenever you want. It's a revocable trust. You can go ahead and add to it. You can go ahead and do anything you want to it. The non-grantor trust is typically what we call an irrevocable trust. And we'll go into more detail on that a little bit later. But anybody who's giving money to their non-grantor trust, their irrevocable trust, that money, $5,000, tax it. $500,000, tax it. And he also wants to go ahead and tax his main distributions of debt. He wants to eliminate what he calls the government subsidy for inherited wealth. Ladies and gentlemen, he is truly, in his statement, on the warpath against the step up in basis. Absolutely on the warpath. And it's sort of like one estate planning, national estate planning individual compared it to what Canada's had since 1972, by the way. There are some exclusions. He's got a little bit of a heart in this. And the exclusions are to avoid gain recognition, $1 million in unrealized capital gains in life and death. So you got basically $1 million, anything above $1 million, he's after. $250,000 to $500,000 for personal residences. Some tangible personal property, but Jerry and I were just talking about his baseball card collection. He doesn't have one, or do you have one? In any event, anybody's a collection like that, the baseball card collections, I have one. Those might be an issue because they might have some significant value. Think about your Babe Ruths and your Ty Cobbs and your, all various other ones you can think of. What's that?
Shoeless Joe.
Shoeless Joe. By the way, did anybody see the ball game last night? And that was in the old Chicago White Sox outfit. It looked like Shoeless Joe. I wasn't sure if we were actually looking at a ghost. Donations to charity, but basically not necessarily the charitable trust. And then some assets are held in retirement accounts. Those might have the exceptions and so forth as we proceed. Assets held in the grantor trust. This is another one. So hey, say I'm 54 years old. I set up a non-grantor trust to hold certain assets that I don't want to be countable against myself in the future, against that $3.5 million that we might be coming down to. When I set that up, 21 years from now, at age 75, boom, they're going to act as if I just put it in there for the first time as I sold it. And they're going to tax. Say I put in $500,000. They're going to tax $500,000, just like that. I didn't do anything with it. I didn't sell it, buy it, trade it. But they're going to tax it. That's what Senator Van Hollen wants to do. Allows income tax to be paid 15 years after death. So what he did is, okay, they taxed me at 75. I then went ahead and lived until I was 90. And at age 90, they are going to give me 15 years to go ahead and pay that tax, or whoever's my survivor. Now, this is the part that's probably most scary about it. It is proposed to be retroactive to January 1st of this year. So money that we try to go ahead and put somewhere or another right now might be taxed. Now, many don't believe that this will be retroactive. But that's what the bill says. And the many, as I refer to the many, I'm referring to estate planning attorneys, people who are analyzing it, tax attorneys, and so forth. Could that inhibit gifts this year? Yeah, you bet, it might. It sure might. With this law, grants. Now, I'm not sure if any of you have what's called a grant, but it's a grantor retained annuity trust. And basically, it's putting a larger asset within the context of a trust. A certain amount gets spinned off each year, but by the time that the time period for the grantor retained, or the grantor retained annuity trust is completed, at the end of that, basically it's tax-free, it's cleansed. Not so, says Senator Van Hollen, according to his approach. So let's compare the plans. Now, by the way, I have provided to each of you, as you came in, a chart that shows these. So they're all basically summarized and so forth, so that you have that. But just give you an understanding what Donald Trump put in place for us. Then we've got Joe Biden's bringing us with our exemption up, basically the highest income tax rate, 39.6, and now taxing at a little lower level from 523 to 400,000. The highest capital gains rate balloons. Now, that's ballooning almost to twice as much, from 20% to 37%. That 37% doesn't kick in until $1 million. Gift annually without tax, again, under the current plan, we're at $15,000 unlimited. With Joe Biden, we're at $15,000 maybe. With Senator Bernie Sanders, he said, yeah, but you only make 2 of those gifts, or only 30%, or 30,000 overall. And then, of course, we've got Senator Van Hollen, who we talked about, is on the warpath. We've got the gift estate tax exemption, $11.7 million. It's part of a combined unified credit. President Biden takes it and pulls it on the campaign trail apart at $3.5 and $1 million. Same thing with respect to Bernie Sanders. They echo each other. And then you've got the warpath. Then you've got the estate tax rate, 40%, 45%, but not the plan, maybe even up to 65%, which we saw in the campaign. And then we've got Bernie's then, 45 to 65%. And then we have the capital gains and step up in basis. Yes, currently it exists. Not the way that Joe Biden wants to see it, not the way that Bernie Sanders wants to see it, and certainly not the way that Senator Van Hollen wants to see it. And I gotta tell you, until earlier this year, I'd never heard of Senator Van Hollen, and I apologize if I've introduced any of you to Senator Van Hollen today. But that's what the situation is. Going back to our chart here. So we're gonna go through each of these kind of quickly. What can we do? How do we handle this? What can we do now to soften the blow? Okay? So again, we've got the income tax rate that we talked about. We've got the gifting, both annual exemptions and lifetime exemptions. We've got the estate tax exemption, the estate tax rate, the capital gains and step up in basis. We've got the charitable gifts, which are tax-free.